Let's go ahead and start. We've got a good group here. I want to say welcome and happy new year, everyone. Thanks for your continuing support of this project as we are working our way through our draft bill. I'm glad to see everyone. Hopefully you have all the materials that you need. We have Krista sent out the agenda and resent out Jimmy Brewer's memo, which we'll be talking about. But before we get into the sections we're reviewing today, we'll just take a brief report, first from Jim Nance on our jurisdiction section, and then from Heather Merrick on the topic of default judgments. We've had some issues that have come up in our discussions, and people have branched out to have subgroups to talk about those particular issues. Jim, on jurisdiction, I did see an email. I was in another meeting, but I did see you send an email this morning saying that your group met, and we will circulate this summary after this meeting, but maybe you could give us just a high-level report of what your group has done and whether you're done meeting and the email has your recommendations.
Thank you, Justice Duncan. I think we are done meeting. The consensus of the Justice and Municipal Court Judge members of the work group is that they would like to leave ORS 51.050, which addresses the criminal jurisdiction of justice courts as is, except for subsection 2. Subsection 2 of that statute addresses transfers of misdemeanor cases, and the consensus was that we could move that subsection 2 into a freestanding statute, but that otherwise subsections 1 and 3 should remain as they are. Similarly, with respect to the civil jurisdiction of justice courts, which is addressed by section 2 of the draft bill, subsection 2 combines ORS 51.080 and 090, which is fine with the judges, except that they would like to leave the wording exactly the same as it is in the current statutes. And there's some additional wording that was added to the proposed amendment, particularly subsection 8, which addresses that the jurisdiction of the justice court in civil cases is not exclusive, that the subgroup thinks is not necessary. And then lastly, I don't know if the whole work group is aware of this, but in the course of doing something else, I ran across a statute that actually, I think it's two or three statutes that address neglect and abuse of animals, making those mostly violation cases. And the statute says that the justice court has jurisdiction of those cases. Oddly enough, it doesn't say municipal courts also have jurisdiction, and the work group thinks, or the judges group thinks that it should. Also, the statute says for a repeat violation, I think for a third or subsequent violation of those statutes, that the DA may choose to prosecute as a Class C felony. The suggestion is that the Class C felony could be prosecuted in justice court, but the judges agree that that statute should be amended to clarify that if the DA chooses to prosecute as a Class C felony, it should be brought in circuit court, not the justice court.
And Jim, I know we came across this animal abuse statute before, and it did raise the whole issue of whether that was one special category of felonies that under current statutes at least could be brought in the justice courts. And if this proposed change that you just mentioned is made, am I correct in understanding that there's no felonies that would be prosecuted in the local court? This would take care of that anomaly?
Yes, although I believe it was Justice Cross brought to our attention that apparently there are instances where a felon can be arraigned in justice courts, and that occasionally this happens, particularly in the eastern part of the state. And so, and also municipal and justice court judges have the authority to issue search warrants that could result in felony charges. So we have to be careful about not about saying that they have no felony jurisdiction at all, because they have this tangential jurisdiction. And frankly, that was part of the reason why the judges would like to leave the current wording of ORS 51050 alone, because it does refer to criminal jurisdiction. And if we take that out, the fear is that we somehow affect the jurisdiction that the justice courts currently have in those felony related matters.
Okay. But for our purposes, talking about appeals from the local courts to the circuit court, we don't expect any cases to come to felony judgment out of the local courts.
Correct.
There would be no felony adjudications from a justice or municipal court.
Okay, especially if we clarify this animal abuse limitation that you've suggested. Great. So I did see in the chat, Krista has sent Jim's email to the group. We don't expect you, and I don't even want you to read it right now while we're engaged in our review of the bill. Everyone will have that email. It's a lot to digest just orally in these few minutes. So please, after the meeting, take your time to look at that and let us know if you have any reactions to the information in the email. So thank you for that update, Jim. And I know Heather Merritt was going to work with Justice Kidd on some issues relating to default judgments. Don't know if you've had the chance to do that yet, but you just want to provide a quick update to the group.
Heather, in my meeting, it's tomorrow, so it will post date this, but we have exchanged sort of our thoughts
Okay.
the current state of the law. So that's
Okay.
we're on track.
Do you want to tell the rest of us your intended focus, so that if there's someone who wants to join your small group, that they could?
Sure, I think Jim's on there too. So what Heather and I are trying to do is kind of mash out, get kind of a common understanding of whether defaults are appealable. So Chapter 51, if you read it together, seems to suggest they're not. And Heather has pointed out that some of the sort of 1990s reworks of the just general appeal statute may override that. So I think the statutes are in conflict. I think she and I don't quite share a common understanding of it, but we're going to try to harmonize, or at least figure out where each other comes from. But that's really the focus of that meeting, is the default issue.
Great.
And to be clear, if it's not already clear, this is a situation that arises in appeals of violations, not in criminal cases.
Right. No default judgments because someone wasn't present, because they need to be present for the criminal case to go forward. Okay. Great, thank you for taking that issue on. Something to think about may be that if there's a default judgment in the local court, perhaps the next thing that someone would do would be to file a motion for a recall of the judgment, and maybe the only appealable thing from that would be the denial of the motion to recall. But you will think about that and bring your expertise to how we should have a recommendation about how these appeals, if any, should proceed. Great. Thank you all for your work on those subtopics. Today, we're going to be continuing our conversation about the types of cases that are appealable. And we have Jimmy Brewer's memo, regarding sections 15 through 18, and primarily sections 16 through 18 of our draft bill. I hope you've had a chance to review both the memo and those sections in light of the comments in the memo. The first one I'd like to talk about is section 15. Section 15 talks about the availability of writs of review. There, and we mentioned this last time, the writ of review statutes. We have section 15, and it is based on 2 existing statutes, which just do what we intend section 15 to do, which is to say, we have appeals from local courts to circuit courts, but those are not intended in any way to affect the availability of a writ of review. So whatever you can bring by writ of review, you can still bring regardless of the appellate process. My recommendation is that we leave section 15 in the current law as it is. There's a suggestion that we mentioned last time to stick in the writ of review statute numbers into section 15, so it's clear what we're talking about and it's consistent with the current statutes. But for our group to, and I know that Jim, you have some thoughts about this, but for our group to figure out whether there's still a need for writs of review, there could be some perhaps redundancy between having appeals and having writs of review, but I think that writs of review are, say it informally, a completely different can of worms. And I don't know that we have the capacity to go figure out exactly what they cover and whether what an appeal would offer would be a complete substitute for them. So my inclination is to not alter the availability of writs of review at all. I just don't know that we have the bandwidth to make sure that we're not doing anything we don't need to do. So that's my take, but anyone else? Jim, I know there's some concerns about, do we really need writs of review if we have these appeals? But if anyone has any thoughts on that, please type up now. Jim.
If I had, I since this is not my area of law, I don't know how often writs of review are sought in violation or misdemeanor cases being prosecuted either in justice court or municipal court. So I did wonder, is this one of those anachronistic procedures that we no longer need? But I agree that I have not heard of any problems with them, so maybe we ought to let that sleeping dog lie.
Heather, I see your hand.
I was trying to find notes on this, and maybe others know offhand. It was my understanding that the writ of review is permitted in circumstances where other remedies aren't otherwise available. And so if that understanding is correct, maybe there wouldn't be a redundancy.
So if it exists as a backstop, it makes sense to leave it as a backstop. Anyone? Oh, any other thoughts? Okay. Well, that's easy. Yay for us for leaving leaving section 15 as is, with the technical correction. So that gets us to section 16 through 18. And these are the types of violations and misdemeanors that can be appealed. And really, a lot of what Jimmy brings up in his memo is we are talking about appeals from local courts to circuit courts, and those are generally de novo. But if we say that there are appeals from things like guilty and no contest pleas, restitution judgments, probation violation judgments, what does a de novo proceeding look like in the circuit court? So Jimmy's laid these out in the memo, and Jimmy, if I can, what we'll do is we'll talk about a particular subject area. You can say what the problem is, or what we might need to do to clarify what an appeal would look like from, for example, beginning with the guilty and no contest pleas, and what we might have to do in a draft to specify what we mean by an appeal. So would you mind talking about guilty and no contest pleas first? And these are covered by paragraph 16(1)(a) of the proposed draft. So Jimmy.
Okay, so for 1A, I think this is a question that the existing draft deals with or attempts to deal with, but I think it deals with it in kind of a clunky way that maybe we can streamline a bit. So there are two parts I sort of have an issue with. One of which is really just the phrasing, the defendant may appeal only the sentence. I think that's a little imprecise. Ordinarily, we would say what you're appealing is the judgment, and then what you can get review of on appeal is sort of a separate question. And I think introducing the concept of appealing a sentence is going to maybe make it difficult for somebody who's reading the statute to understand, oh no, I'm just actually supposed to appeal from the judgment in this case, just like every other case. I think the point, though, is that we shouldn't be having a whole new trial if you entered a guilty or no contest plea. You should just be getting a new sentencing. The other part of the language I have trouble with is the court may review only to determine whether the trial court failed to comply with the requirements of law in imposing or failing to impose a sentence. I think as a general in these appeals, the circuit court isn't going to be able to review the justice court's work in the same way that the Court of Appeals could review the circuit court's work because there's no transcript. So I think really the only thing that the circuit court can practically do is just do a whole new resentencing. And that would be, I think, what we just need to specify more clearly. You're not trying to determine whether the justice court imposed a legally permissible sentence, because that depends on facts and stuff that the circuit court doesn't know. The question is just, okay, circuit court, we're just going to do this again. Start from the fact that there's been a guilty plea. You're not going to reconsider that. Just go ahead and sentence this person.
What do people think about that? Would you have any experience appealing sentences out of the local court, following guilty or no contest pleas? And what do you think sentencing only proceeding in the circuit court would look like? Justice Kidd.
So I have had people appeal my sentence and then they got a whole de novo trial, which was a weird thing to have happen because the circuit court just didn't know what to do with it. So I think this is an improvement. I kind of like the language that we have right now because it's, I think, readable to a person who's not trained in the law, and that is by and large the people who are here in my court. I think they understand what appealing the sentence means. And I actually think it's not actually hard to figure out if a sentence complies with the law. It's at least in violation land, which is where I work. If it is a Class A violation, you're either within the permissible range or you're not. So I don't think there's difficult, knotty factual questions to deal with there. And so I like the language that exists as is.
Do I understand you to say, like, you're thinking that the circuit court would do a reviewing function or they would just do a resentencing?
I think that they should just do a reviewing function, really, right? Like, I think they should say, is this something that complies with the law? Like, you pleaded no contest, right? Is the sentence within the discretion of the court below? And if it is, I think that it should stick.
And then Tony Ross, I saw your hand up next, and then Heather and Jimmy. Tony.
Right, thanks. So I, when I was advising people in the municipal court, mostly in Eugene, sometimes in Springfield, handling those cases, I don't remember seeing we wouldn't usually advise clients to appeal just a sentence because we would tell clients there was a risk that you're going to get a worse deal. And a lot of the municipal court judges kind of thought about that, I think, in terms of what sentence they gave to sort of put an end to it there. That's one thing. But as I was looking at so I'm saying I don't know how often it happens. But the one thing I was looking at as I looked at this section, I wondered about an issue which might arise if there was a question about the plea, whether the plea met the requirements of law. So a person's entered a guilty plea, but I remember years ago, at least a couple of cases I had in municipal courts where the plea was given. I thought, well, that probably didn't meet all the requirements of law. So a client might, or a defendant might say, I'm thinking of criminal cases here. You know, I didn't really understand that, or something went wrong. So I don't really know what the answer is on that, if the current statute even addresses that. But what if there's something wrong with the plea? So I throw that out there.
Right, right. And I know Paul Smith and perhaps other people who have worked on this, when you have, this language was taken from the criminal appeals involving criminal cases from circuit court to court of appeals. And Paul and some other folks were on the work group before this one that updated the criminal appellate statutes. And if you have a situation where there's a guilty plea, a lot of the questions about the validity of the plea, whether it was knowing, voluntary, whether all sorts of questions that do not really relate to the sentence imposed are off limits. Is that right, Paul? Is that right, Paul?
Yeah, that's my recollection, and that's what I am just looking at what the statute says right now.
So,
It says the validity of the plea is not subject to review. This is for in the Court of Appeals from a circuit court conviction.
so Tony, that if the language is the same, because we've taken it from the circuit court appeals to local courts, it would be really limited to just, is this a legal sentence? And we would have to think about whether we'd have how to clarify, if at all, if we would need to, that the plea issues, voluntariness and things like that wouldn't be appealable.
Justice Duncan, if I could add something here. I included this material in the draft that I sent to Legislative Council somewhat reluctantly. These, well, part of this is being driven by the fact that if a violation or misdemeanor is heard in the circuit court, certainly the misdemeanor is subject to these provisions under current law. Similarly, I think if a misdemeanor case is prosecuted in a justice or municipal court of record, the appeal would be governed as it is under current law, the same as if it were brought in the circuit court. And a lot of the sentencing review stuff is in the current statute, not because it applies to misdemeanors, but because it applies to felonies, because of the whole presumptive sentence and the judge having the authority to impose a greater or a lesser sentence based upon current factors. So I have this awkward situation where we have this appeal regime that was originally enacted because it was felt necessary for felony cases, but because felony and misdemeanor appeals are treated the same, they also apply to misdemeanor cases, although I don't know of any published Court of Appeals decision that addresses the sentence in a misdemeanor case. And now we're talking about importing it and making it applicable to violation cases. So the first question I have is, should we limit these provisions to misdemeanor cases and not even apply them to violation cases? But if we do decide to apply them to violation cases, since they are also applicable to misdemeanor cases, I think we have to use pretty much the same language that would be applicable to a misdemeanor or violation case heard in a justice or municipal court of record, because those rules are the same as a violation or misdemeanor case heard in the circuit court in the first instance.
Okay. And then we'll go to the folks with their hands raised, and the order I had was Heather, Jimmy, Dan, Jordan. Heather?
I had a comment related to this distinction between courts of record and courts that aren't courts of record. And that was just thinking through what the appeal of a sentence would look like out of a court that isn't a court of record. And how that reviewing process would look. Even some questions that we would characterize as legal involve a significant factual inquiry. And I'm thinking in particular about Article 1, Section 16, Oregon's provision against excessive fines and disproportionate sentences. And that involves looking at the gravity of the specific conduct involved and comparing it to and also looking at facts like around the person's ability to pay and so I think I'm just like, in my mind, it's a little complicated what that would look like coming out of a court that doesn't have a clear record that could be reviewed.
Yeah.
Without doing a de novo kind of review at that point.
Thank you. And Jimmy?
Sure. So on a similar point, and I should sort of cabin this by saying when I wrote what I wrote, my focus really was on misdemeanors. I don't deal with violation cases. I don't know as much about violation cases. It may be the case that for a violation case, you can just look at the judgment and tell whether the sentence is right or not. And it may also be the case, I don't really have a position on this, that none of these categories of appeals that we're discussing should apply to violation cases. Maybe they should be limited to criminal cases. Certainly some of them in practical effect are really only going to apply to criminal cases. But as to criminal cases, as to misdemeanor cases, it certainly is the case that you cannot just look at a judgment and tell whether the sentence is correct. Probably the two most consequential things in misdemeanor sentencing, or legal determinations at least, whether sentences can be imposed consecutively and whether convictions merge, are dependent on the facts, really the facts that underlie the conviction. And anything that's put in the justice court record, the circuit court isn't going to have access to unless you do a whole nother proceeding. So I think at least for misdemeanor appeals, you really do need to resentence if you are actually going to. There's no way for the circuit court to review whether the justice court applied the law correctly if it doesn't know the record on which those rulings were based.
Okay. Thank you.
Oh, and just one more, I don't think it's the case that there are no published cases concerning appeals on sentences in misdemeanor cases. There are a number, particularly on those questions of merger and consecutive sentencing.
Judge Cross.
Well, just to go back to the originally started back when I raised my hand, I think that I agree that a guilty or no contest plea, I don't think that's subject to appeal or review, but I do think the sentence that you do get, getting a de novo review on the sentence, I don't have a problem with. My guess is that most circuit court judges are going to probably only look at it in their mind under an abuse of discretion type of standard, although that's certainly not the standard that would exist for de novo review. But in any event, if it goes before a circuit court judge and a circuit court judge wants to give a lower fine than I gave, I don't care. If they make that decision based upon what's presented there. And I think but that to me, that's the one avenue for de novo review that would exist at that stage of a violation. Is the sentence and the sentence only. If the sentence was unlawful, I mean, if a person appeared in front of me on a Class A violation and I imposed a $5,000 fine, I expect the circuit court is going to fix that in a heartbeat. I think it makes sense to keep that as an avenue for de novo review for a defendant appellant.
Okay. And then Jordan.
Thanks. I think some of what I was going to say is duplicative now, so I'll just say I agree. I think de novo review on sentencing makes sense for the reasons everybody else has said. But the one question I still have is if we're going to limit this to what the sentence was, and we're gonna say there's no way to file an appeal on the procedure of the plea. So was the plea knowing? Was it voluntary? What's the remedy for challenging that then? And I'm legitimately asking, I don't know the answer to that. I suspect in circuit court, in the world of circuit court, it's post-conviction relief. But I've never heard of PCR in a municipal court setting.
Jimmy, are you answering? Is your hand up to answer that question? Oh,
In the circuit court context, it would certainly be post-conviction relief and not an appeal. And I think it would make sense for that to be the same for justice courts. As far as I can tell, the post-conviction statute would apply to a conviction in justice court. It says any person convicted of a crime under the laws of this state. So potentially not convictions for municipal ordinances, but conviction of a state law offense in a justice court would seem to be something you could raise in a post-conviction proceeding, or at least that's the assumption that I've had thus far.
any other thoughts?
But where would that be appropriate to be raised? Would it be appropriate as part of an appeal to the circuit court for de novo review? It doesn't seem that's the right vehicle, but it doesn't seem like there's currently an avenue for it to go directly anywhere else.
Is the idea, Jimmy, that it would just go to post-conviction? You just have to file a post-conviction claim in the
Right.
court
Right.
alleging that your plea was not knowing or voluntary, or you had inadequate representation if you had representation.
Does the
Yes,
current
and-
PCR statute contemplate that?
I believe so.
From a justice or municipal court?
I don't,
Okay.
I would leave the
I haven't looked at
language.
it, I haven't looked at it forever, so.
Sure. The only thing I would say is it would be filed in the circuit court of the county for which the petitioner's conviction and sentence was rendered, which seems to
Right.
leave open that that county could include a municipal or justice court. And if you're filing a PCR petition from that, you'd file it in the circuit court there. It would be a separate case, but that's how every PCR petition is.
All right. Good to know. Thank you, sir.
Huh. Thanks, Jimmy.
And Heather, I see your hand.
I had a clarifying question. Jimmy, are you saying that it wouldn't apply to municipal offenses, that it's only state offenses? Or crimes?
As based on my reading of the statute, it only applies to a person convicted of the laws of this state. But I would note that if it doesn't include municipal offenses, that would be true regardless of whether the conviction is in circuit court or justice court. And if you're convicted based on a plea of a municipal offense in circuit court, you aren't going to get review of that on appeal either. So if there is a gap here, the gap is really in the post-conviction statutes, not in the justice court appeal statutes.
Well, except that the gap could exist in the post-conviction statutes because in the appeals statute, they assumed you were getting a de novo trial if you appealed.
Well, if I'm jumping in, up until this point, as I understand current law, you cannot appeal a conviction based on a guilty plea from a justice court to a circuit court. Current law does seem to allow you to appeal a conviction based on a no contest plea, but that probably was an oversight.
So Heather, I see your hand is still up, and then I see Lindsay, your hand. Heather, did you have a follow-up?
Yes, just that I wondered whether we might flag this issue for when we get to the municipal court appeals. So that, I mean, if I'm understanding correctly, the way, if we were to mirror this in the municipal context, we would be saying that we might be limiting appeals, which might involve crimes. There are municipal level misdemeanors. And maybe the post-convictions, we would be here we're assuming the post-conviction process might provide an avenue for challenging issues there, but that avenue wouldn't currently be available in the municipal context.
And Lindsay.
Thanks, Justice Duncan. I just wanted to apologize that I don't have OJD's official comments on this particular issue yet. My understanding is we do de novo trials, and that's the current framework. So I'm not sure yet the challenges that we might have with doing a sentence review. So I will get that feedback. We are frantically preparing for the 2024 session. But I will do that as soon as I can and get that back to all of you.
And Lindsay, I think if I'm understanding the sense of the group, there's this possibility that it could be a review of the sentence for legality, but alternatively, it could just be a resentencing because of the difficulty of doing a review for legality when you don't have the factual record, that it just might be the most expedient thing for someone to come to the circuit court. They have the plea's been entered, that's not at issue. It's just the circuit court judge would be in the position of imposing sentence based on that plea. And then that would put the person from that point forward in the same position that they would be in if they've been in a municipal or justice court of record. And that's my understanding. Looking for a sense from the group if those are the two options, and it seems like the second one where there's a full resentencing might be administratively easier if that is helpful for OJD to figure out what the burdens on the circuit court might be. That sound like a correct description of what we've just covered? Okay, seeing the thumbs up. Okay. Okay.
Well, just one thought is that perhaps we can clarify in section 16 that the circuit court's scope of review is de novo. Currently it just says the court may review only to determine blah, blah, blah. If somehow we can insert the words de novo to make it clear exactly what that scope of review is.
Right, I think that what we're saying here is that simply talking about this in the terms of reviewability, like the Court of Appeals does for circuit court decisions, doesn't really work for the review from the local court, and it would be a resentencing, like a de novo sentencing proceeding, and we could say that affirmatively, which would be very different language than what we have here. If that's the sense of the group. So, okay, so we would redraft section 16. If there's no further thoughts on section 16, let's move to, well, section 16B, sorry. A was guilty and no contest pleas. B is restitution judgments. Jimmy, same sort of issue. Do you want to talk about the restitution judgments?
Sure. So this is taken from the appeal statutes governing appeals from the circuit court to the Court of Appeals. And the reason why restitution judgments need to be dealt with separately there is that you can have situations where the judgment is entered on day one, and then 90 days later, the state comes into court, as it's permitted to do under the statute, and says, we want restitution for this case. And at that point, there will be a restitution hearing held, and a supplemental judgment will be entered. And you may have situations where there's nothing wrong with the original judgment, the defendant was fine with the sentence they got, but then at the restitution hearing, the court, as it always does, makes a bunch of legal rulings, and now the defendant has some problem with that. So for the defendant to be able to appeal the restitution decision, that supplemental judgment needs to be appealable. So that's how it works in the circuit court going to the Court of Appeals, and that's why this was sort of copy and pasted from that. That's why that's here. In principle, the same thing can arise in criminal cases that are tried at the Justice Court. The state can come in 90 days later, after the time for appealing the original judgment has expired, and the court can enter a supplemental judgment imposing restitution. And the defendant may have been fine with the original sentence, but now And particularly in misdemeanor cases, the restitution judgment may include amounts far beyond what was really on the table in the original sentencing. So I think it makes sense for those to be appealable, but I think we want to make clear that the only thing that would get redone in such an appeal when the original judgment wasn't appealed is just the restitution hearing. You're not resentencing everything. You're not reconsidering the plea or reconsidering the trial. You're just considering, was this the correct restitution amount?
Paul, I see your hand up.
I'm wondering about a situation where the defendant is otherwise happy with the sentence, as you say, Jimmy, but is dissatisfied with the restitution amount. I'm trying to figure out what that looks like on an appeal to the circuit court, again, because of the record problems that we were talking about earlier. I mean, there might not be. I mean, are we just envisioning that the prosecutor is just going to put on again evidence of what the victim's damages were, and then just have the circuit court kind of reevaluate what the total damages were, de novo again?
I think that's an important point and one of the practical difficulties we get into. Just to expand it for everyone who might not be familiar with this area of practice, if in some cases the original case judgment was based on a plea, in that case, the evidence that presented at the restitution hearing is pretty much all the evidence on that subject that the Justice Court would have considered. On other cases where there's a trial, Justice Court is probably going to be relying in part on what was presented at the trial, not just in determining the causation and the amount of damages, but also what the underlying crime was, because there has to be a link between that and the damages. And you could potentially get into situations where redoing the restitution hearing before a court that didn't see the original trial is going to have to get into a lot more facts than the Justice Court looked at that restitution hearing. I think that's a fair problem, and I'm not sure it's a problem that can really be solved beyond saying, yeah, sometimes the prosecutor is going to have to present additional evidence that they didn't at the original restitution hearing, just to build the full record.
Well, and I wonder also, I don't know to what extent things like compensatory fines are available in municipal court. I mean, I know sometimes when there's a problem of proof for restitution, a prosecutor will say, well, fine, let's just call it a compensatory fine. And so I worry that if there's an appeal and we limit the review just to the propriety of the amount of restitution, and there's like right now, if that happened in the appellate courts, the whole case would be sent back for resentencing, where the sentencing court could kind of rebalance again if it needed to, and the prosecutor could ask to have the restitution imposed as a compensatory fine instead. And I don't, so I don't, I want to make sure that to the extent that there's under current law an opportunity for kind of that rebalancing to occur when there's an appeal of a restitution issue, that's not lost if we say that an appeal, a de novo appeal of just the restitution issue, can just look at restitution, nothing else.
So just to clarify, my understanding of the law was that, so if you're doing compensatory fines can only be imposed at the time of the original judgment. And if you do restitution at the time of the original judgment, you can do what you're saying, to say, well, I don't think restitution, but I am going to impose a compensatory fine. I don't think you could do that in the circuit court, not if the restitution is 90 days later. So, and it seems to me that if we're dealing with a case where restitution is imposed in the original judgment, this is just covered by the statute we were just discussing, and you would get a whole new resentencing. And if restitution is done 90 days later, then this idea of sort of balancing it with the compensatory fine isn't really available. But maybe I'm wrong about this circuit court sentencing authority in those 90 days later hearings, but that was the assumption I was operating under.
And I could be wrong about that too. It's been a while since I've done one of these, so I was just operating under a different set of assumptions.
Would it help the process if the appeal notice request, we don't, because there's been talk about developing a standardized form for that, which I think certainly think would be very helpful, where a defendant could check the box that what they are appealing is specifically the restitution. So the circuit court has precise notice of what is coming before it.
Well, I think they would have to include the judgment with the notice of appeal, and the judgment in the cases that we're talking about here, the judgment would just be the supplemental judgment. So as soon as the circuit court looks at the judgment, they'll see, oh, this is just going to be about the restitution.
But if the restitution was part of if there wasn't that, if it wasn't supplemental, but didn't come 90 days later, it would be all in one order.
Yes, that's correct. And in that case, you'd just be appealing the one judgment. But I think in that case, for the reasons that Paul Smith just said, in fairness to both sides, you'd really want to have a whole new resentencing rather than just taking one part out and looking at that alone.
Well, I'm saying, but if that's the one issue the defendant had, I think they could elect that option.
So I think the parties could certainly go to the circuit court and sort of stipulate, look, we were completely fine with everything else the justice court did, just do that and then do restitution separately. But there might be cases where the defendant or the state, where the defendant says, I want to just challenge restitution. And the state says, well, no, hang on, if we're going to change restitution, we need to change some other things as well.
So Paul, would the issue that you've raised, we addressed if, like Jimmy is saying, if someone is appealing a supplemental judgment, challenging restitution, then the case goes to the circuit court for a full resentencing. That way, if, for example, the local court had imposed no fine or a minimal fine because it wanted to impose restitution, but then it turns out it actually couldn't impose restitution because it was not for the crime of conviction, that the circuit court could take that into account. And then you would end up with a larger fine and no restitution if that was what the
Yeah, I mean, that's what I'm thinking. I haven't thought about mechanically how that works. And again, I know that happens when in appeals from circuit court that are reversed on any type of sentencing error. Really, we usually want the sentencing court to be able to kind of restructure. I mean, to comply with the law, obviously, but to the extent that there's discretion to be able to effectuate its discretionary choices at the same time. And here, if we're having a de novo sentencing entirely, that at least allows the circuit court as a de novo sentencing court to consider everything and not just be everything related to the sentence, at least, and not just one discrete part of the sentence, in this case, the restitution.
I understand that point. Lindsay, I see your hand up.
I think that is a good point about how the circuit court will know what its inquiry is, because if the notice of appeal is filed in the lower court and then the whole record is sent as a bundle to the circuit court to initiate the case, there's going to need to be some way for the court to know what is being appealed, how it's properly being appealed. I mean, the supplemental judgment, the restitution judgment, the original judgment might all be together. And the circuit court doesn't know when the original judgment was entered necessarily. And so whether it was timely, if the lower court is doing that whole inquiry, then there'll just have to be some way to make sure to communicate that piece formally to the circuit court.
So in cases involving supplemental judgments, when we're talking about what the local court is transferring, for if it's a supplemental judgment, we should say the judgment being appealed is supplemental judgment, but it actually might have the effect of appealing the original judgment as well, and then requiring transfer of those related records if we want the circuit court to have the flexibility that Paul's talking about. Okay. Yep. So we'd have to be clear that the circuit court could reconsider the original judgment to the extent of the sentence. Okay. Any reactions to that idea? Jimmy, I see your hand up.
Sure. I mean, I think once we work out what the law is, that concern may or may not go away. I think certainly if they're appealing the original sentence and part of that is the restitution, then everything is on the table for better or for worse. If it seems to me if the Justice Court didn't have authority to reconsider the earlier sentence at the later restitution hearing, the Circuit Court shouldn't be able to reconsider that on appeal from that either. But I think this maybe goes to a question that I'm not totally certain on. It sounds like Paul Smith isn't totally certain on, which is what would the Justice Court's authority at that restitution hearing be?
Can I ask
I'm
those?
puzzled in what sense? I mean, if the case is adjudicated there and the conviction occurs there, it's the restitution power is as it would be for any other court.
So, how often does it come up where there's the original sentencing hearing in the local court and then the restitution judgment is entered later because information needs to be gathered? And then the question is, what authority does that local court have to modify anything that it has already done? Any ideas on that, Tony?
Well, I certainly know, as defense counsel, I would object, if restitution fell on its face and the judge said, well, I'm going to give you a bigger fine, because I think that's already been decided. And I think the parties in the cases I've been involved in, you're really treating those restitution hearings as more of a civil case. Just, how much did the broken door cost? And I will note that I'm not practicing anymore, but over the years, and at least in municipal court in Eugene, we'd see these restitution figures go up a lot. I mean, thousands of dollars, and I was representing mostly indigent people. Insurance companies get involved. The prosecution has victims assistance, so that will augment the information available. I would say I would object. I would object on the basis I don't think the municipal court judge would have authority to enhance a sentence already given if we're just dealing with restitution at a restitution hearing.
Other thoughts? So, Paul and Jimmy, could I enlist you to kind of figure out what the Justice Court's authority would be to modify the sentence that it had already imposed at a supplemental restitution hearing? And you guys could report back or email us about that, and because that could affect whether whether the circuit court would have any greater modifying authority. Okay, great, thank you.
My concern with doing that is that then there would be discordance between the law currently governing appeals from misdemeanors in circuit court and appeals from justice or municipal courts to circuit courts. I mean, I understand that there may be a latent issue there, but I'm wondering whether this is the appropriate forum to resolve that issue.
Well, and if I can just respond to that, I agree, and I think what I want to figure out and talk to Jimmy about is make sure we're on the same page as to what our understanding of the law in appeals from circuit court convictions and restitution imposition is, because I think I think as much as possible an appeal from a municipal court or a justice court should mirror what the rule is if we're talking about misdemeanor convictions. And it sounds to me like Jimmy and I just need to figure out what we think the law currently is in the appellate courts.
Thank you for being willing to do that. Did I hear someone? Okay. We have about 4 minutes left, so what I suggest that we do is just flag what lies ahead along the same line of like, what does the de novo appeal look like in these special situations? We have probation judgments and amended and corrected judgments, and conditional pleas. And Jimmy's memo covers those. So at our next meeting, we'll cover those issues. Jimmy and Paul, if you see any overlap between those issues and what we've talked about today, and you have suggestions when you're talking that you want to bring back to the group, that would be great. So any other?
Well, Judge Kidd sent me a text. He lost his internet. So
Oh.
he disappeared from the meeting and he wanted to pass along his apologies, asked me to pass along his apologies.
Thank you, thank you. Okay, and we have our next meeting. Krista, the meetings are what is our recurring meeting date? It's the second
Wednesdays, yeah.
second Wednesdays of the month. So we will see you the second Wednesday in February, and thank you everyone who's working on side projects between now and then.
Well, it should be on your calendars. It's the 14th, Valentine's Day.
Valentine's Day.
Also, I believe Oregon's birthday. I think
Oregon's
it's both.
birthday.
Yeah, there you go.
Great. All right, well, we'll see you all then. Thank you.
Bye, everyone.